Good day. This is the YMC Education Series. We are free and open to the public, so we encourage you to spread the word and invite family and friends to participate. We host approximately 6 to 8 of these a month. Welcome to join us. If you have any questions for Matt today, just put it into the chat box. We'll be able to get to it. We might not be able to get to it at the end during the session, but we'll try to get to it at the end if he has time. Thank you again for joining us. I'd like to welcome Matt Margolis. And he will be speaking to us proactive, not reactive, and teaches about the importance of planning ahead when you have a chronic medical condition. Thank you, Matt, and welcome.
Thank you, Pam. All right, I am throwing my information in the chat box, so everybody has my contact info. I'm going to do my best to.
And Latisha asked the screen, what is that?
I'm going to do my best to get through all the information today in a pretty timely manner. I told Pam I've got like a hard stop in about 40 minutes at 9:59. I've got a 10 o'clock meeting I have to jump into that kind of came up last minute. Unfortunately, I'm sorry, kind of a personal matter. But we will get through it. But I did put my contact info in there in case you have any questions and we can't cover them today. You can always shoot me an email or give me a call. We can discuss them after the fact. So, you know, really quick about me. So my name is Matt Margolis. My law partner, Lauren Weldon, and I have a boutique elder law and estate planning practice in downtown Park Ridge. And we assist people all ages with their estate planning needs and elder law needs. So, you know, half our practice is really dedicated to helping people with wills and trusts and powers of attorney. We do some special needs planning. We do some asset protection work. We do powers of attorney for 18-year-olds going off to college. And then the other side of our practice, on the elder law side, we do a lot of work related to Medicaid, helping people apply for Medicaid, protect assets while applying for Medicaid, and just sort of being a general resource for folks that are dealing with an older loved one who's going through some sort of transition. You know, ultimately, when people are dealing with a loved one, sort of like in that final chapter or last chapter of life, you know, there's a lot of issues that can arise, and people typically aren't prepared for that. And so in some cases, we're just a resource, and somebody might reach out to us and you know, we can provide a little guidance, but in general, maybe we're just going to connect them to other resources that will better suit their needs at that moment. So today's talk, right? Proactive planning when living with a chronic medical condition. So for anybody that's attended some of my talks in the past, there tends to be some little bit of I was gonna say rollover, but you know, there's information that kind of is covered in multiple talks, because there's just certain things that come up in various circumstances. And so really the goal of the talk today is to talk about, you know, I'm talking about proactive planning when somebody has a chronic medical condition, but really it's just the idea of proactive planning in general, right? I mean, and the idea and the concept that we know that we are all better off when we plan ahead. When we are proactive versus reactive, we are going to be much better prepared, and we are going to have a lot more options. And so, yes, I mean, this sort of the spirit of this is for somebody, you know, especially being proactive when maybe we're faced with some sort of a diagnosis of some sort of chronic illness. But the reality is that, you know, us being, let me just turn my computer a little bit, us being proactive is important, really, no matter what, because, you know, yes, if I'm diagnosed with dementia, it's important that I get my planning done, and we'll talk about that. It's not to make you see those garbage bags in the background. Maybe I'll go back to that. Sorry. You know, yes, it's important to obviously plan when you have some sort of serious diagnosis, obviously. But the reality is, you know, there's a lot of people that I've worked with over the years, and I've been doing this now for almost 11 years exactly. I want to say like in a month or two, or in a week or two, I'll have been doing this for exactly 11 years. And I can tell you that I've met with plenty of people where they weren't, and I mean, and I take this with a grain of salt, they weren't fortunate enough to be given a, you know, diagnosis and had some time to prepare for something that was coming on the horizon. Believe me, I am not saying that being diagnosed with dementia or some form of dementia is ideal, but from a planning standpoint, at least if somebody doesn't have their planning in place, now they can do it. There are situations that we encounter where somebody in their 60s or 70s or 50s who's otherwise, super healthy, all of a sudden has a debilitating stroke. And they never did their planning prior, and now they really don't even have the opportunity to do it at this point in time, right? Because now the stroke has rendered them incapacitated. So yes, it's important to plan and be proactive when we're faced with some sort of serious diagnosis. But in general, really the spirit of this talk today is to just be proactive when it comes to planning. One thing that occurred that I saw during the pandemic was that a lot of younger couples were doing some planning, which is awesome. I can say that for the first 9 years or so of my practice, it was pretty few and far between that I'd work with anybody under the age of 45 or under the age of 50, frankly. It was, our average client and the typical clients we work with would, be probably age 55 or older. And most of them were doing some planning for the first time ever. And so, I think with the pandemic, a lot of, younger working individuals, working parents were at home and realized, oh, we can meet with an attorney via Zoom. We don't have to take time out of our busy work schedules to leave our office downtown or our office in the suburbs and meet with an attorney at his or her office. And so, it was nice to do some planning with some younger couples. It's good to get our planning done, right? Nobody does planning with us. It might not be, it's not that it might not be stressful for some people. I get that, obviously this is what I do every day, so it doesn't really faze me. But I totally understand the idea that doing any kind of estate planning can be stressful. It can be emotional. It makes people think about their mortality. And I totally understand that. And again, as I was saying, I sometimes just get very caught up in the fact that this is what we do on a daily basis. But believe me, there's been clients that I've worked with that, have been crying in meetings and honestly for no other reason than it's just, to them, the idea of planning for their passing and what will happen with their stuff is a pretty emotional task. So I maybe went off on a tangent here, but again, what I was gonna get at is nobody's upset once their planning's done. Nobody complains and says, oh gosh, I'm really upset that I put that estate plan together. The overwhelming majority of people are excited that they've done it. They are relieved that they have this in place so that they don't need to worry about it anymore, because for so many people, it's been one of those things that's been on their to-do list for so long. For those clients that we work with that have children, for the most part, it's been on their to-do list since that first child was born. Because that's when people started saying, oh, hey, you should probably have a will in place to name guardians for your minor children. So again, I keep on saying this, the idea of today's talk is yes, if we are faced with some sort of serious illness, for sure planning becomes imperative. But the reality here is that we need to be proactive regardless. It shouldn't take a chronic illness or the diagnosis of a chronic illness to make us plan. We all understand that planning is important and that it's imperative, frankly. And I don't care, what kind of plan you do, how fancy it is, the bells and whistles, but having some sort of plan is imperative, in my opinion. So on a very basic level, okay, and especially in a situation where we're diagnosed with some sort of chronic illness, getting powers of attorney in place are so important. I think a lot of people kind of pass over these documents. They're like, oh, those are so simple. I can just get them online. And yeah, you can get these documents online. People can put these together on their own. I don't advise that people do that, because inevitably what people do is they don't fill them out the right way. Right. So yeah, they've saved some money and they've gotten them done sort of, in a much more cost-effective manner than having to hire a lawyer. But if somebody signs a document and it's not signed correctly, or it's not notarized and it needs to be notarized, or somebody witnesses the person's signature who's attempting to sign the document and it's an invalid witness, Yeah, they saved some money putting this document together on their own, but now they have a document that's invalid. And God forbid they become incapacitated before they're able to execute a new one. Now they don't have a power of attorney. So the reason why we put powers of attorney together, so these are documents where we are naming somebody, to make decisions for us in the event that we can no longer make our own decisions. And so in Illinois, we have two types of power of attorney documents. We have the healthcare power of attorney and the property power of attorney. And the healthcare power of attorney is where we're naming somebody to make medical decisions for us in the event that we are no longer able to make our own. We can name as many people as we want on that healthcare power of attorney, but it's one at a time in a particular order. Okay, we cannot name multiple people to act together. Illinois does not allow that for good reason, right? If a serious medical decision had to be made for me, the last thing I want is for two people to be fighting over what decision to make. And so for the healthcare power of attorney, I can name as many people as I want. It's one person at a time. Okay. And I want to make sure that I'm naming the right people. This shouldn't just be like, oh, I've got 4 kids and I'm going to name them oldest to youngest. Maybe that is the right order, but maybe it's not. Right? Maybe my youngest child is actually the best person to be making medical decisions because, I don't want my life artificially prolonged. I don't want to be hooked up to machines. I don't want to be on a ventilator. I don't want to live the rest of my life with a feeding tube. And maybe my 4th child is the one that would actually respect those wishes. And as hard as it would be to honor them, he or she would do that. Versus maybe my oldest who wouldn't, and who would have a hard time making that choice for me. Because at the end of the day, we want to name somebody that will be comfortable, or as comfortable as they can be, stepping in and making our decision for us. My healthcare power of attorney is not doing me justice if they're uncomfortable making the decision I would want them to make. I don't want to name somebody, or I shouldn't name somebody that's not going to respect my wishes. And so it's important that I also talk to these people ahead of time. Right, so I always advise clients, and obviously I can't guarantee that they will have these conversations or not, but I always advise clients, and my partner does the same, to talk to the people that they're going to name. Make sure that they're comfortable making these decisions. It's as much of a blessing for somebody to tell us that they will not do it or that they're uncomfortable in that role as it would be for them to tell us that they are. Because if we're naming somebody that's ultimately going to be uncomfortable, it's a waste to name them in the first place. Okay. The property power of attorney is where we're going to name people to make decisions for us related to everything that's not medical. Okay, who can have access to my checking account, my savings account, my IRAs, my 401ks, my life insurance policies, who can deal with my house or my condo or my apartment that I'm renting, who can file my tax returns, who can deal with issues that might arise with Social Security or Medicare, who can file a Medicaid application on my behalf, who can sign a contract if I'm moving in, if I have to move into an assisted living or memory care facility or a nursing home, who can sign the contract hiring a caregiver to come into my home and take care of me. These are all things that my property power of attorney will handle on my behalf. So I obviously want to name somebody that's appropriate, right? Somebody that's, and so I get a lot of clients that kind of go down this road of, oh, my daughter's a financial advisor, or my son's a lawyer, or my nephew's a CPA, he or she would be the best person to be my property power of attorney. Because they're kind of thinking like, oh, these people kind of deal with things that are more financial, and the property power of attorney is more of a financial matters, which it is. And so the reality is, yeah, maybe those people would be the right people to name. Okay, and like the healthcare power of attorney, we can name as many people as we want, but it's one at a time in a particular order. But maybe some of those people, even though so and so is a lawyer or a CPA or a financial advisor, maybe they would not be an appropriate power of attorney though. If my client's son is a high-powered attorney downtown who is, who's working 60, 70, 80 hours a week, and, not because he wants to, but is rarely even able to spend a ton of time with his family, he's probably not a great power of attorney, because if I become incapacitated and I need somebody to step in and start making decisions on my behalf, how will my son have the time to do that? So it doesn't have to be somebody that's a lawyer or a CPA or a financial advisor. I always tell my clients that power of attorney for property that you're naming, I want them to be somebody that's good at managing a household. Who's good at making sure bills are getting paid on time? Taxes are filed when they should be. Something breaks in their house, they're hiring somebody to fix it. These are good property powers of attorney. It's somebody that can step in and get things done. I also tell my clients, I'm like, hey, you're not a lawyer, you're not a CPA, you're not a financial advisor, but somehow you're able to figure out how to handle your thing, everything you do on a daily basis. Why do you think that your power of attorney has to be, fit into one of those categories, right? So just something to think about, right? The power of attorney, again, we want to just make sure it's something that's resourceful, somebody that will get things done. And it goes without saying, somebody that we trust. And whether it's the first person that we're naming or the fourth person that we're naming on the document, we have to trust this person, because we are giving them access, okay? And it can be accessed only when we're incapacitated, or it can be accessed starting from day one. A lot of my clients, the vast majority of my clients, will sign the property power of attorney so that it's effective immediately, so that it's effective the day that they sign it. Okay. And a lot of them do that for matters of convenience, right? It's not that they can't handle everything that they're doing. They can, and they will continue to. But my power of attorney, for example, was effective the day I signed it, because there's just a matter of convenience. What if I need my wife or want my wife to be able to sign something or handle something on my behalf at some point? Even though I'm totally capable, again, I may just want her to, or need her to, or it would be convenient for her to. And the idea is that we're trusting the person that we're naming regardless. So who cares? I mean, this is my 2 cents. Okay, everybody can look at this differently. But my perspective and my opinion is, I obviously trust this person to step in and handle things appropriately if I'm incapacitated. And if I'm incapacitated, I have no idea as to whether they are acting in my best interest or not. And I think we would all agree. So why would I be uncomfortable with the document taking effect immediately, with the idea that if I needed them to step in at some point and do something for me, they could? So just something to consider, right? We're not signing powers of attorney with anybody on this talk right now, but this is just something to think about. And it's something I discuss with all of my clients. The reason why these powers of attorney, I'm going to get back to it, are so important is that if I am incapacitated, if I am at a point where I can no longer make my own decisions, whether it's medical decisions or financial decisions, and I don't have a power of attorney, then somebody is going to have to hire a lawyer and petition a court to be my guardian, my legal guardian. And we want to avoid that at all costs. Guardianships can take time, and I can tell you right now, they will cost money. You're probably not looking at anything less than $3,000 or $4,000 to deal with a guardianship. And then once somebody's appointed as a guardian, if they want to do certain things with that person's money over time, they have to go to court and get permission from the judge to sell a house, to apply for Medicaid, to move into a long-term care community. They need to get permission for these things, which means more attorney's fees, because guess what? You've got to bring the lawyer in court to represent you and petition and request these things from the judge. So don't wait, okay? I can't say it enough times. Don't wait till that happens. Don't allow that to happen. Get your powers of attorney in place in time, right now, while you have the ability to do it. Of any estate planning document, wills, trust, anything, all of them, of all those documents, get those powers of attorney in place, okay? Can't stress it enough. And then when we talk about being proactive, so obviously the first thing to me is getting powers of attorney in place. And for most clients, this will be the first thing, right? So a client will reach out to us and say, hey, I have this diagnosis. This is what we're dealing with. And the main goal will be to get powers of attorney in place. Typically from there, we'll say, okay, now that we've at least got our bases covered with the powers of attorney, what else should we be looking at? Well, this is where we get into the conversation of wills and trusts, right? And what's the most, what's the best path to take? And I'm not going to go into tons of details on wills and trusts and all the various intricacies, but we'll talk about it at a high level to some extent. So when we look at planning and we look at the idea of what's going to happen with our estate when we pass away, we are looking at two main documents that we're going to be choosing from. We look at the idea of a will or the idea of a trust. And in its most basic form, a will, which I'm going to say is probably the more comfortable document, if you will. I think the will is the document that most of us are more familiar with is the better word, right? I think we're more familiar in concept with the will, just because it's probably that document that we've heard of over the course of our lives, right? My mom had a will, my dad had a will, my grandma had a will. That's the document that people always throw around. And I'll tell you, even people that have trusts in place still refer to them as, oh, my will, just because it's more of that household term. And then on the flip side, I'm going to say that a lot of people are not as aware of sort of what trusts are and how trusts work. And there's a lot of people that I meet with that have this idea that trusts are only for the Pritzkers, so to speak. Trusts are only for people that are really wealthy and have lots of money. And the reality is that that's not true, right? The simple fact is that that's not true. People that have lots of money can definitely benefit from the use of a trust, because we can use trust to help avoid or minimize estate taxes when they pass away. But in Illinois, we have an estate tax limit of $4 million per person. So while we do want to prevent against that, the vast majority of people will not have that problem. Okay, the vast majority of people will not have an estate tax problem. But most of us will have a probate problem. And probate is the process. It's a court process, okay, whereby our estate can go through probate at the time that we pass away, depending on how we owned things during our lifetime. And so again, it's just important that we put a plan in place that's going to honor what we, not only where we want all of our stuff to go, but how it goes to those people or those places, depending on who or where we're leaving money to. So with a will, I pretty much tell clients a will is like a letter to the judge. Because with a will, we're more likely than not, we will go through probate when we have a will in place. And so again, like I was saying, a will is like a letter to the judge. I pass away, I've got a will, the executor of my will, which is the person that I'm naming to handle my estate. The executor hires a lawyer, the lawyer goes to court, and the judge says, boy, if I only knew what Matt wanted to do with his stuff, it would make my life a whole lot easier. And the judge is looking to see that I have a will. And in its most basic form, that will is a letter to the judge. Dear Judge, my name is Matt Margolis. I passed away. If my wife survives me, she gets everything, and she's the executor of my estate. If she doesn't survive me, I want my brother to be the executor, and everything will go to my 2 kids in equal shares. Great. But again, with a will, I'm typically dealing with this court process. And the probate process in Illinois, we mainly deal with in Cook and Lake County, but in general, for a simple estate, it's not uncommon to see a time frame in probate of anywhere from 1 to 2 years and $5,000 to $10,000 in attorney's fees and court costs. And that would be for a pretty simple, straightforward probate where everybody gets along, nobody's fighting, people aren't arguing, other attorneys aren't being brought in the mix. And, there's not 5 different pieces of real estate that have to be sold, 40 different bank accounts and investment accounts that have to be dealt with. A pretty simple, straightforward estate is going to kind of fall into this 12 to 24 months and $5,000 to $10,000 of fees. So sorry, my 2-year-old's being a little crazy downstairs, so maybe I'll put my headphones on. There we go. Can you guys hear me? Okay, good. So make sure. So even with a pretty simple probate estate, we're looking at 1 to 2 years and $5,000 to $10,000. And the reason why we go through probate, even with a will, okay, is when we have an estate or we have assets in our name that exceed $100,000, and those assets do not have beneficiaries on them, and they are not owned jointly with somebody else. Okay. So again, if my estate, if the total okay, of assets that are in my name only, that are not owned jointly with somebody else, and obviously jointly with somebody that survives me, as long as those assets are not owned jointly with somebody else, and they do not have a beneficiary, then if those assets total over $100,000, they will go through probate, even though I have a will in place. Okay, a will by itself does not avoid probate. Now, if I have a will, excuse me, that says everything goes to my friend Pam Rakansky at the North Shore Y. She's been so helpful over the years. I'm going to leave her everything I have. So if my will says everything goes to Pam, but the reality is all my stuff, all my assets are owned in joint tenancy with my wife, and my wife is the beneficiary of everything, then the reality is nothing goes to Pam, sorry Pam, and everything goes to my wife, because beneficiary designations and joint ownership supersede language in a will. Okay. So in reality, there are some people that kind of, have what I kind of refer to as the poor man's estate plan. And I don't mean anything by that, I really don't. But the idea is that they've created an estate plan based solely off of joint ownership of assets and beneficiary designations. It's not something I recommend, because it doesn't take into account various contingencies and things that can happen over the course of our lifetime, things that might happen to those beneficiaries, things that might happen to that person that's joint on my account before me. But those are ways to avoid probate. And so I don't want to lose track of the idea that avoiding probate and having a proper estate plan are two totally different things. I can avoid probate just by slapping beneficiaries and everything and adding somebody as a joint owner on all my stuff. But that may not be the most appropriate estate plan. Okay. So there's this concept of a trust. Okay. And the way that a trust works is going to be very similar to a will, right? The trust is going to dictate who gets all of our stuff when we pass away. And so let me just finish with the will really quick. So with the will, we have executors that we name, and that's who's going to step in and administer my estate, who's going to hire the lawyer and go to court and deal with the probate process. Okay, so those will be my executors. And I can name as many people as I want, one at a time. I can name multiple people to act together as co-executors. And then obviously I have beneficiaries, right? Who's going to inherit everything. With a trust will be very similar, except with a trust, I name trustees. Okay, and the idea of a trustee is very similar in concept to an executor who's going to manage my trust when I cannot. The biggest difference between a trust and a will, for the majority of people, right? For those of us that don't have a taxable estate, we don't have more than $4 million, and we're not needing to avoid estate taxes. Okay, because I'm not going to talk about that today. So for most of us that are just creating a trust to avoid probate, to avoid that probate process, to avoid that 1 to 2 years in court, $5,000 to $10,000 of attorney's fees and court costs, we will use what we call a revocable living trust. Okay, the revocable living trust will be the document that we use that will be sort of similar in concept to a will, right? In the sense that this is what we're going to use to make sure that all of our stuff goes to the people that we want it to go to. But this trust will allow us to avoid probate. The trust operates off my social security number. So my life doesn't change. My taxes stay the same. Everything stays the same. The way that I avoid, and I am what's called the trust maker. So I'm the one creating the trust. Over time, I can make changes to the trust. Okay, so something in my life changes, I can amend the trust as long as I have capacity. If I lose capacity, no more changes. From day one, I'm also the trustee. That means I get to manage and control what's in the trust. Well, what's in the trust? Well, the way that we avoid probate with a trust is that we actually have to retitle our assets to the trust. It's not good enough to just go to a lawyer and put a trust in place. We have to make sure that our brokerage accounts and checking accounts and savings accounts and money market accounts, and we need to make sure that all of that stuff and our stocks are retitled to our trust. If we own real estate, whether it's a house or a condo, we have to retitle that real estate with a quitclaim deed that we record with that county. And we transfer ownership of our property from us to our trust. Now, retirement accounts do not go in a trust. So IRAs, 401ks, 403bs, those are not going to be owned by a trust, but those will stay in my name. And I'll just want to make sure that my beneficiaries are always up to date on those. Okay. Same with the life insurance policy. The life insurance policy will stay in my name. I just want to make sure that those beneficiaries are up to date. And in some cases, not every case is a little bit different, but in some cases, we might name the trust as the beneficiary of an IRA or a 401k or a life insurance policy. Now, as trustee of my trust, now that I've just retitled all of those assets of mine to the trust, I can do whatever I want with them. I can continue to deal with my checking account, my savings account. I can make decisions with respect to my brokerage accounts, etc. I don't lose control of anything. The trust is not, I'm not giving up control because I have a trust in place. So as trustee, I manage all that stuff just like I did prior, and my life literally doesn't change. Now I have successor trustees listed on the trust because at some point I might be incapacitated. And if I'm incapacitated, then that successor trustee is going to step in and manage those assets in the trust for my benefit during the rest of my lifetime. And the trustees of my trust, very similar to the executors of my will. I can name as many trustees as I want, one at a time in order. I can name multiple trustees to act together as co-trustees. I don't really love naming more than two at a time, right? We've kind of all heard the phrase, too many cooks in the kitchen. But we can name as many trustees as we want. And so the trustee might step in during my lifetime if I'm incapacitated, and for sure the trustee will step in upon my passing to ensure that all of my expenses are taken care of, my bills are paid, any real estate is sold. At the end of the day, you know, I kind of say all my money kind of gets consolidated into this bucket, and then the trustee distributes it to the beneficiaries. And of course, when it comes to beneficiaries, we can leave our money to whoever we want to. Children, grandchildren, nieces, nephews. When we leave money to charities or any kind of, you know, charitable organization, it's typically pretty simple. You know, we're going to give, you know, 5% of the estate to this charity, 5% to that charity, etc. And they're going to use it for their general charitable purposes. When we leave money to individuals, we can leave it to them in one of two ways. We can leave it as an outright distribution, meaning everything goes to my two kids, and there's $1 million left. They each get a check for $500,000 and they can do whatever they want. That would be an outright distribution. Or we can leave it to them in trust. What does that mean? That means that, so for example, my wife and I, our trust says that everything goes to our two kids equally. However, if they are under the age of 30 at the time that we pass away, then two separate trusts kind of spring out of our trust. One for the benefit of our son, one for the benefit of our daughter. These aren't separate trusts that we're drafting. These are sort of what most of us will maybe think of when we, you know, maybe we went to college or high school, or we know somebody who's like a trust fund kid, right? Whatever that meant. So we're going to create our own trust fund kids. Sounds silly, but just to kind of give you the idea, you know, that's sort of what it would be, right? And the idea is that, you know, we don't want our kids to have access to the money before they're 30. We don't know how responsible or irresponsible they're going to be. And so we give them the money in trust, and then the trustee, which would be my brother, would manage the money for their benefit and would use it for them at his discretion until they turn 30. My wife and I were still living and our kids needed money, they would come to us and ask, and we would either say yes or no. That's what the trustee is going to do now. Okay. In a perfect world, our kids are over the age of 30 at the time we pass away, and it never goes into trust, and it just becomes an outright distribution to them. Okay. Now, whenever we leave money to any beneficiaries, whether it's children, grandchildren, friends, other family members, any individuals, we need to have a backup plan in place because they may not survive us. And so we want to be conscious of where would that person's share go. These are things that we can solve for in a trust or we can solve for in a will. But in a lot of cases, we cannot solve for them just by naming somebody as a beneficiary on a checking account or a savings account or a money market account or an IRA, or having them as a beneficiary on our house through a land trust or whatever it might be. Some of these things don't necessarily allow for these contingencies, and that's why we really advocate that somebody put a will or trust in place, because there's sort of these built-in contingencies. And again, of course, we hope these things don't ever happen, but God forbid somebody didn't survive us. Most of us would rather the money go in a certain direction than just go in some other direction by default that the bank has determined is the right way for it to go based on how we name somebody as a beneficiary on an account. So for the sake of time, for the last 4 minutes here, really quick, I want to kind of switch over. And the type of trust we've been talking about is a revocable living trust. So this trust avoids probate, okay? And for certain people, it can help avoid estate taxes if that's the problem, but it's not going to protect our assets. And so if we're concerned that, you know, based on some kind of diagnosis we have, or we don't know what the future is going to look like, and we're getting older, and you know, we don't want our spouse to be left with nothing, and we're concerned that if one of us needs long-term care, you know, we don't want to impoverish our spouse. There's a different type of trust we can look at, and that's an irrevocable trust. Okay, and so there's a trust that we draft in our office, and different attorneys give it different names. We call it a Medicaid asset protection trust. And really the concept behind it is that if my wife or I, okay, ever need long-term care, and we need long-term care for a long period of time, you know, we want to make sure that we're not impoverishing the other person, right? And some people that we work with, they're already widowed or they're divorced, and while they don't have a spouse that they're concerned about impoverishing, it's important that they leave something to their kids or their grandkids. Everybody has their own wishes and their own desires as far as where they want to, some kind of legacy or something that they want to leave behind, whether it's to a spouse or kids or grandkids. And so in those situations, what we might look at, and this is where we have, it's ideal to be proactive, is the idea of an irrevocable trust. And we'll use an irrevocable trust to actually protect our assets. So if we ever apply for Medicaid in a nursing home, Medicaid has a 5-year look back period, which means that if we give any money away within the 5 years prior to applying for Medicaid, it'll be an issue, okay? There'll be a penalty. And I have another talk that I give where I go into Medicaid in much more detail. So you know, I'm gonna kind of leave you with a little bit of a cliffhanger today, but I'd advise that you check out that talk because we'll go into more details. But Medicaid is a 5-year look back. And so the idea is, you know, if we plan ahead of time, if we are proactive enough, we can use this irrevocable trust to put some of our assets in it, so that as long as 5 years goes by after we put our assets in that trust, if we ever need long-term care and we ever get to a point where we can qualify for Medicaid based on what our assets look like outside of what we put in that trust, because that trust would be off limits after 5 years, then we can potentially apply for Medicaid and never have to spend down that money that we put in that trust. Okay, but this is really where being proactive comes into play. Okay, while we can help families and couples protect assets on the doorsteps of applying for Medicaid or moving into a nursing home, we can definitely protect more assets if we do it prior and we do it ahead of time. Now, this trust is a little bit more restrictive. Okay, this type of trust for the asset protection aspect of it, I can't be in control of it, so I have to name somebody else as the trustee. So in a lot of cases, my clients will name their adult children as the trustees of this trust. Similarly, I can't be the beneficiary of this trust during my lifetime. So with a revocable trust, I'm the beneficiary during my lifetime. With this type of trust, typically, my adult children would be the beneficiaries during my lifetime. It has to look like it's not for my benefit. for Medicaid to allow this money to be protected and for it not to count against me, it cannot be looked at like it's there for my benefit. And so without going to any more really intricate details, I just wanted to give everybody an idea that there is an option to protect assets. And this does come up very often for folks that are concerned or that have some kind of threat of a long-term illness. And so, I mean, I really just want people to understand that there is the ability to protect some assets. But again, people have to be really conscious of the time frame that they're working with it when they're doing this. It's one of those things where you really don't want to delay. And obviously, as we know, the sooner we act, the better. I mean, that's all it is, right? And all it is that, when we delay and when we wait and the longer we wait, I mean, I can tell you that this happens with clients and prospective clients all the time. The last thing I'll say, because I have to jump, unfortunately, into a meeting, is that, sorry, I just got this person reaching out to me right now. Sorry. So the last thing I'll say is that I've met with clients plenty of times over the years where they wait too long and then we've lost our options and we've lost our ability to plan. So please don't wait. But on that note, I have to run, unfortunately. So I'll let Pam end it. And please tune into another meeting where I will go into more detail on some of these things Medicaid related. Bye, guys.
Thanks, Matt. If you do have questions for Matt, I see a couple. He put his information in the chat box and he does respond to emails pretty quickly. So you can email him there. I probably won't be able to answer it. So if that works. All right, I'm going to close out. Thank you for attending today. I'm sorry Matt had to jump off early today. His next talk will be on April 6th, planning strategies for the caregiving child. So talking more about if you're an adult child, taking care of your parents. And so that'll be on April 6th. On Monday, we do have a talk in honor of Women's History Month, talking to us about body image resilience. So look forward to talking to you in the future, and hopefully you can join us in April. Thank you for joining us today.
Thank you, Pam. Have a
Thank
good day, everyone.
You too. Thank you.